When they pick up in court today for day 2 of jury deliberations in the Trump criminal trial, the jury will be hearing at least part of the judge's legal instructions, and there will be readbacks of testimony before they begin their deliberations again. Among the things that the jury is interested in, testimony from former National Enquirer publisher David Pecker regarding a phone call with Trump, testimony from Pecker about his decision to not fund Karen McDougal's story, the former Playboy model who alleged a relationship with Trump. They want to hear testimony from Pecker about a meeting at Trump Tower and testimony from Michael Cohen about a meeting at Trump Tower. With me in studio this morning, Bonnie Sard, a former assistant district attorney in New York County, and Jeremy Saland, a criminal defense attorney and former assistant DA in the Manhattan DA's office. Good morning to both of you.
Good morning.
We're all sitting trying to glean every bit of information we can from these jury requests. Bonnie, where do you think this jury is at right now?
I think the jury is trying to assess the role of the former president and the role of Michael Cohen in all of this. The judge instructed the jury that they've got to have some corroboration for what Michael Cohen told them when he testified as a witness, and certainly both lawyers, Josh Steinglass and Todd Blanche, focused on the testimony of Mr. Cohen in their closing arguments. And I think they're trying to see if there's enough corroboration for what he had to say regarding Trump's role in this catch-and-kill scheme and ultimately in the false documents.
Is it fair to say, Jeremy, that they're circling around the aspect of this case that deals with the election and whether this was influencing an election?
Well, absolutely, that's a huge part of it. If you look at this, it's all born in 2015 at Trump Tower, and that's readback that they wanted. They wanted to hear about that. And that puts Michael Cohen with Pecker and Trump starting that initial conversation. But it's more than that, because then you have the telephone conversation where at some point Donald Trump says, I'm not buying the story, but you know what you do? You talk to Michael Cohen. And that corroborates further that who's the man who does this all? Who keeps a clean hand? It's Donald Trump, and the bad guy in this relationship is Michael Cohen. So it corroborates, as Bonnie said, the whole story, the whole narrative.
So for those of us who don't spend all day, every day in a courtroom, when the jury asks about the judge's instructions, did they have a copy of the judge's instructions like I do, or it has to be all verbal?
In New York State court, it has to be all verbal. It sounds sort of crazy, right? Like he spends an hour reading these instructions to them, and
right. I mean,
won't
I've
give
got
them
50 pages.
Exactly. And you know, years ago, I had a jury out, and after they deliberated, one of them complained to the judge and said, "Gee, it's like I bought a piece of furniture at IKEA. I couldn't get the instructions, but I could have them read back to me anytime I wanted them." And it's a great analogy, but right now that's the rule in New York State, so they can have it read back to them by the judge at any point in time, but they cannot receive a copy of it.
Very quickly on that, Pat, I know in federal court it's a little different. You can actually get them. There's an argument to be made that I don't want that jury, especially if there's a lawyer on that jury, to read the jury instructions in there. They may do that anyway in terms of talking about it and discussing it, but interpreting it on his or her own and sharing that with that jury. I'd rather hear it from the mouth of the court to say this is what the law is. And if there's a question, you come back and ask again. Don't just read it on your own and try to interpret it.
So I want to go to page 44 of the judge's document. Again, the jury won't actually have their hands on this, but it says, although you must conclude unanimously the defendant conspired to promote or prevent the election of any person to public office by unlawful means, you need not be unanimous as to what those unlawful means were. He's saying there has to be some sort of crime, but you can each view the nature of the crime to be different?
That's relatively speaking fair. And Bonnie and I were just discussing this before. It could be, an example would be a burglary. The purpose of that trespass is the same, or pardon me, a trespass is a trespass, but the crime you're committing could be to steal something, could be to damage something, to commit a sex crime. It doesn't matter, and you don't have to prove that piece beyond a reasonable doubt.
What happens here in terms of all of those charges? Does the jury at some point go through and say, we agree that this was fraudulent, we agree that this was fraudulent? Is that the easy part in terms of looking at each of those individual checks and business records?
Well, certainly the jury can go about their deliberations in any manner that they want. Oftentimes they may be guided by the foreperson who's just appointed as the first juror sworn, or in this case it may be that they're guided by the two lawyers on the jury. They may be turning to them for advice. They can do it in any manner or any order they choose. But here, where you have 34 counts, you know, one might assume that they would say, well, look, were these false business records and were they created in furtherance or to conceal another crime? And then go through them one by one. My understanding is that not all of the checks, for example, were signed by Donald Trump. So we could potentially see a split verdict where they convict on some of the counts and acquit on others.
How powerful is the desire of a jury to get out before the weekend? Or will things like that play into it, or are these jurors now in for the long haul? And if it's 2 more days of deliberation, does that matter?
I think they'd likely want to get out before the weekend, generally speaking, but this is such a unique situation, and the gravity and magnitude of this case, I'm sure, is not lost on them. The ripple effect is going to be enormous. No matter what they decide, it's going to have huge implications. So I'd like to think that they don't care about the weekend, but we're also all people. I would not be shocked if that's an element too.
Bonnie, where does this go next? If Trump is convicted, there will inevitably be an appeal.
There will be an appeal. My suspicion is there'll be more than the standard appeal. I think that the defense would probably make a motion to set aside the verdict. They would do that relatively quickly, as is required by law, telling Judge Merchan that there was some defect or irregularity during the proceedings that would necessitate him setting aside the verdict. The step after that would be an appeal to the First Department, which is the first level court, appellate court here in New York.
Jeremy, quick final thought.
I think that I'd like to tell you that there's going to be a conviction or a hung jury. I can't give you that answer. I can only say to you, I'm fairly confident, if not overwhelmingly so, this is not an acquittal. And I think the nation and the city need to get this done and over with to move forward sooner rather than later.
We will be busy with it today. Thank you both for making time for us this morning.
Thank you.